applications, and we will start voting in the maximum application of ASM,
Thank you. Lord Panic, just before you start, two things. First of all, we're very grateful to Council for having obviously worked hard and negotiated hard overnight for the replies. And secondly, my Lord Justice Underhill just wishes to raise an issue that is slightly troubling us so that you're aware of it. Not you personally, I mean you collectively.
Thank you. One of the points, Lord Panic, though this may be in Sir James's territory, that Mr. Hussain made, and I think is in the Stoton arguments as well, relates to the fact that these decisions were all certified. My understanding, and if this is wrong, I would want to be put right, is that the fact of certification means that the Secretary of State has to be satisfied, not simply that Rwanda is a safe third country, but that any argument to the contrary is clearly unfounded, which on the face of it requires a higher level of satisfaction than the FTT would have to reach if it hadn't been certified and the matter had gone to the FTT. Now, it may be more subtle than that, but that's the position on the face of it. And then there's a separate question of what our role is, or the court's role is, in reviewing the Secretary of State's decision. And in Yogathas, I think, but again, I would welcome some help on this, it is made clear that the court's role is only one of review, but quite what it means to review a decision that there is, that an argument is clearly unfounded is not entirely straightforward, and not asking you to deal with this on the hoodoff unless you possibly want to, but if it can be covered by you or Sir James at some point in the morning or early afternoon, I'd be grateful.
Well, we have given thought to that. Sir James will deal with it. Can I suggest it's probably best if Sir James deals with that at the end of my submissions?
Yes.
Thank you.
Can I raise just one other small housekeeping point?
Yes, of course.
I've been looking at, in connection with this, at the certification decisions, and in the case of RM, we have the letters from Wilson's, in his case, which raise the human rights claim, which is then certified. We don't have the equivalent letters, I think, in the AAA cases. I'm not personally, I would want to see all of them, but I would want to see one of them, so that I could see exactly what the Secretary of State was certifying.
Well, we will find those for you. Thank you very much. My Lords, I was developing my submission in response to Mr. Hussain, Mr. Drabble and Ms. Dubinsky that the Refugee Convention permits the receiving state to remove an asylum seeker to a safe third country, and Article 31 is no restraint on that entitlement. That's the submission. And I was going to take your Lordship, if I may, to what Professor Hathaway says on this subject, because I adopt what he says. Your Lordships will find it in Bundle 22, which is Core Bundle Volume 4, but it's numbered Bundle 22, and it starts at page 3714. The relevant passage starts at 3722.
The only reference you haven't given us is the tab.
I'm sorry, of course, tab 82. And your Lordships may remember that I think it was Mr. Hussain read a part of page 3723 near the top as a reference to the Irish Court of Appeal. But I do submit it's necessary to look at the whole passage to understand Professor Hathaway's views. So can I pick it up, please, at 3722 under the heading Expulsion. And the Professor says there are two exceptions to the general rule that Article 31 bars the imposition of penalties on refugees for illegal entry or presence. First, Article 31 in no way constrains a state's prerogative to expel an unauthorised refugee from its territory. And we respectfully agree. Second, some restrictions on the freedom of movement of irregularly entering asylum seekers are allowed pending regularisation of status, and we're not concerned with that. And then he says it may seem ironic that an asylum country which is generally prohibited from imposing penalties on refugees may nonetheless expel them. The drafters were, however, unambiguous on this point, and there's a footnote reference to the Travo, with Colombia going so far as to suggest an amendment that would have formally disavowed any duty to grant territorial asylum to refugees. The Canadian representative successfully argued that no modification of the text was required, since, quote, the consensus of opinion was that the right to expel refugees who illegally enter a state's territory would not be prejudiced by adoption of Article 31. His suggestion that he would even regard silence on the part of the conference as endorsement of his point of view led Colombia to withdraw its amendment. Indeed, the Netherlands representative remarked that in view of the Canadian representative's statement that he would interpret the silence of representatives as tacit approval of the Canadian government's interpretation of Article 31, he would remain silent. And then there's the reference to the Irish Court of Appeal. As such, the Irish Court of Appeal's worry that Article 31 might interfere with the operation of an orderly system to allocate asylum responsibilities is in fact answered by the article itself. A first country of arrival rule cannot be successfully attacked under Article 31, as the sanction imposed under such systems is precisely expulsion to another non-persecutory state. That's very clear in my submission, and I respectfully commend it to the court. The potentially devastating impact of the clear decision not to preclude expulsion under Article 31 is mitigated, says the professor, by two key factors. First, whatever right governments have to expel refugees is constrained by Article 33's duty of non-refoulement. And we respectfully agree, Article 33 is the constraint. You can't expel other than to a safe country. Any expulsion of a refugee must therefore not expose the refugee, directly or indirectly, to a risk of being persecuted. We agree. Second, in contrast to the situation in 1951, the laws of most state parties today explicitly or implicitly authorise refugees in flight from persecution to enter their territory in search of protection. Refugees arriving to seek protection who have complied with reasonable formalities for the assessment of their claims in such states are lawfully in their territory and accordingly benefit from Article 32's constraints on expulsion until and unless fairly determined not to qualify as refugees. Now, it's important, and then he deals with other matters. Now, all of that is very clear in my submission, and it is correct. It is important to note in the present cases that it is no part of the argument for the appellants to suggest that they can rely on Article 32 of the Refugee Convention. Can I just remind your Lordships what Article 32 says?
Sorry, Lord Payne, just before you, I just want to make quite sure I haven't confused myself. The second of the Professor's two mitigating practice doesn't apply in this case because we, under domestic law, their presence is illegal.
Yes,
Yes.
precisely so. And I was going to take your lordship to Article 32 and then remind your lordships of the authority to that effect. It's high authority to that effect. But could I just, so there's no doubt about this, remind your lordships of the provisions of the convention with which we are concerned, and your lordships find them in the core authorities bundle 19. It's core bundle 1, core authorities, it's numbered bundle 19, and it's at tab number 13, and your lordships will find Article 31 and 32 on page 303 behind tab 13, 303. And your lordships have seen Article 31. Your lordships have seen Article 33, which is over the page. And Article 32 is headed expulsion. And it does impose a restriction, but a limited one. The contracting state shall not expel a refugee lawfully in their territory, save on grounds of national security or public order. Now, that provision is not relied upon, and for good reason. These claimants have not lawfully entered the United Kingdom. See the Supreme Court judgment in the case of ST. I'm not going to take time on it because it's not in dispute, but it's ST, which is at volume 29 of the materials before the court, and volume 29 is headed Third Supplementary Authorities Bundle, and the case is at tab 20, and it's page 347, that's the reference, and it's a judgment of the Supreme Court that lawfully means lawful according to the domestic laws of the contracting states, and a person who arrives at the border who's not given leave to enter, they may be given temporary admission, that's not given leave to enter, is not lawfully in this country for the purposes of Article 32. And therefore I submit that if one looks at Articles 31, 32 and 33, the following propositions become plain. First of all, Article 33 permits the receiving state to return a refugee to a safe third country. That's what it says. That's what Bugdakai decides. That's what Hathaway confirms by reference to the Travo. That's the first proposition. The second proposition is that Article 31(1) does not restrict this power of the receiving state to remove an asylum seeker to a safe third country. The Travo so states. I showed the court what Dr. Weiss said, he being the legal advisor to UNHCR, who'd been closely associated with the drafting. It's what Hathaway says, and it would make a nonsense of the provisions were Article 31 to impose such a restriction. Article 31, in my submission, is dealing with treatment in the receiving state. It's not addressing removal from the receiving state, which is the subject matter of Article 33 and Article 32. And the third proposition, which follows from the first two, is that apart from Article 32, which does not here apply, the Convention does not otherwise restrict the power of the receiving state to remove an asylum seeker to a safe third country pursuant to Article 33. Or to use the language of Professor Hathaway, this is, quote, a state's prerogative to expel an unauthorised refugee from its territory. That's his language, and we respectfully agree with him. We say those propositions are clear from the text, from the authority, Buktakai, from the Travaux, and from the academic authority. There's one other academic authority, just to make plain that we don't only rely on Professor Hathaway authority, though he is. The other authority, there's much authority, the other authority to which I draw attention is Professor Goodwin Gill, another well-known commentator on refugee law. And your lordships will find in bundle 22, if I could ask the court please to turn that up, volume 22, which is core bundle number 4, tab 83, page 3756, the court will see Professor Goodwin Gill and Ms. McAdams' work, The Refugee in International Law, 4th edition, 2021, and the relevant passage is at page 3759, it's the third paragraph on page 3759, where Professor Goodwin Gill and Ms. McAdam say, if the court has that, at the 1951 conference, that's prior to the agreement of the Refugee Convention, several representatives considered that the undertaking not to impose penalties did not exclude the possibility of resort to expulsion. Article 31 does not require that refugees be permitted to remain, and paragraph 2 of Article 31 emphasises this point indirectly by providing the contracting state shall not apply to the movements of such refugees restrictions other than those which are necessary, and they shall only be applied until their status in the country is regularised or they obtain admission into another country, etc., etc. So again, Professor Goodwin Gill recognises that the provision prohibiting the imposition of penalties is not a restriction on the prerogative of the state to remove the asylum seeker, so long as it's a removal to a safe third country. And I therefore submit that the case that's being advanced in its various manifestations by Mr. Hussein, Mr. Drabble, Ms. Dubinsky, is an attempt to invite this court to write into the Refugee Convention restrictions on the power of the receiving state to remove an asylum seeker, which restrictions appear neither in the text nor were agreed by the signatories to the convention. And there is high authority that this is something that the court will not do, not least because the implications of a court judgment are that all of the states which met in 1951 and agreed their obligations are new obligations that will apply to all of them. The authority is the Roma Rights case, Lord Bingham for the Appellate Committee. The court will find this in volume 19 of the bundles, which is Core Bundle 1, Volume 19. It's a tab 27, right at the back of Volume 19, and the page number, the report starts at page 845. And just to provide the context, my lords, this was a judicial review. It was challenging the policy of the Secretary of State, under which British immigration officers were stationed at Prague airport with the agreement of the Czech government, and they were there to assess the immigration claims of those seeking to board planes to come to this country. And the purpose and effect of this policy was to reduce the flow of asylum seekers from the Czech Republic. That was the context. The complainants succeeded on the ground of discrimination, which doesn't concern this court, but they failed by reference to the Geneva Convention. And can I invite the court's attention, please, to what Lord Bingham said for the appellate committee, starting at page 874, the bottom of the page, paragraph 18 of Lord Bingham's speech. Page 874, he refers to Lord Leicester for the appellants, who didn't seek to advance that the appellants were covered by the express provisions of the convention. Plainly they were not, etc., etc. And 3 lines from the end of the page, instead, Lord Leicester urged the convention should be given a generous and purposive interpretation, bearing in mind its humanitarian objects and the purpose clearly stated in the preamble. This is, in my opinion, says Lord Bingham, a correct approach to interpretation of a convention such as this. It gains support from the Vienna Convention, which refers to object and purpose. But I would make an important caveat. However generous and purposive its approach to interpretation, the court's task remains one of interpreting the written document to which the contracting states have committed themselves. It must interpret what they have agreed. It has no warrant to give effect to what they might, or in an ideal world, would have agreed. This would violate another rule in the Vienna Convention. The treaty should be interpreted in accordance with the ordinary meaning. And then just above D, it is in principle possible for a court to imply terms even into an international convention. But this calls for great circumspection, since, as was said in the Privy Council in Brown and Stott, it is generally to be assumed that the parties have included the terms which they wish to include and on which they were able to agree, omitting other terms which they did not wish to include or on which they were not able to agree. And caution is needed if the risk is to be averted that the contracting parties may, by judicial interpretation, become bound by obligations which they did not expressly accept and might not have been willing to accept. And I say, with great respect, that applies here, that the contracting parties certainly did not agree that there should be restrictions on their ability to expel an asylum seeker to a safe third country, subject, of course, to Article 32. And then at paragraph 19, Lord Bingham addresses the concept of good faith. And I mentioned that because Mr. Drabble referred to obligations of good faith. And this was an important part of the UNHCR argument in the Divisional Court in particular. Volume 1, tab 12, page 650 at paragraph 59. And Lord Bingham at paragraph 19 says this: in urging a broader and less literal approach to interpretation, Lord Leicester relied on pacta sunt servanda, which requires a treaty should be performed in good faith. Taken together, these rules call for good faith in the interpretation performance of a treaty, and neither rules open to question. But There is no want of good faith if a state interprets a treaty as meaning what it says and declines to do anything significantly greater than or different from what it agreed to do. The principle that pacta sunt servanda cannot require departure from what has been agreed. This is more obviously true where a state or states very deliberately decided what they were and were not willing to undertake to do. That is, I say, here the case. If the court were to be persuaded that there is some further obligation on the receiving state not spelt out in the convention, contrary to, I say, to all the material that I've relied upon, then a difficulty arises. What criteria? What is the court going to imply here? Mr. Dubinsky and Mr. Hussein say, well, it's a breach of the convention to remove a person to a country which is less safe and less favourable to the claimant. I respond that it cannot possibly be the case that the court is expected to judge the merits of two asylum systems, that is the UK and Rwanda. Such a submission lacks any support in the text, in the travo, in the authorities, or in the academic analysis, and it is with great respect incoherent as a test. What degree of less favourable is decisive in this context? I say the test is very clear. Either removal to Rwanda satisfies the criteria set out in the convention, that is the Article 33 criteria, or it doesn't. It's as simple as that. Nor can the test be whether a detriment is imposed on the asylum seeker, as Mr. Hussein suggested. Removal to a safe third country will necessarily, or at least almost always, impose a detriment on the asylum seeker because he or she is denied the opportunity to claim asylum in the country of their preference. But the convention confers no such right, no such choice on the asylum seeker. Mr. Hussein, with support from Mr. Dubinsky, said, well, removal is a penalty for illegal entry. And I've already made my submission that removal consistent with Article 33 is not a penalty. See the Travos, see the academic authorities and everything else. But in any event, if it matters, I would not accept that removal to Rwanda is a penalty for the purposes of Article 31. The purpose here, and my Lord, the Lord Chief Justice put this to, I think, to Mr. Hussein, the purpose here is to deter the criminal gangs of people smugglers who are taking money from asylum seekers and endangering their lives. That's the purpose of the Secretary of State's policy. Mr. Hussein relied on the Canadian Supreme Court judgment in BO10. I wasn't proposing to invite the court to turn it up again, but it was Core Authorities 22, just for the court's note. Core Authorities 22, which is Core Bundle 4, and it was at tab 77, and it was page 3564. It does not assist, and the reason why it does not assist is because it was not concerned at all, and it did not address at all removal to a safe third country. the Canadian Supreme Court was not deciding whether, as we submit, a state may lawfully, that is consistent with the Convention, remove an asylum seeker to a safe third country rather than consider his or her asylum claim. If that had been an issue before the Canadian Supreme Court, it would have addressed Article 33. It would have addressed Article 32. It would have looked at the Travo. It would have looked at the academic authority and other material. And none of that material, none of it was considered because that was not the issue before the Canadian Supreme Court. Mr. Drabble emphasised, and rightly emphasised, that asylum seekers often make clandestine journeys to a country where they claim asylum, such journeys breaking the law of the receiving state. Of course they do, and Article 31 prohibits the imposition of a penalty because, for example, the asylum seeker has used a false passport, forged passport, for example. But the issue in this case is not whether the United Kingdom may impose an administrative or a criminal or other penalty on the individual concerned for such conduct. The issue is whether the receiving state, here the United Kingdom, is entitled, as we say it is, to return the individual, to send the individual to a safe third country pursuant to Article 33, rather than consider the merits of his or her asylum claim. And for the reasons that I have given, that is the text of the Convention, the Travo, the academic opinion, Bugdakai, I submit that the receiving state has no duty to assess the merits of the asylum claim if it decides, in its discretion, to send the individual to a safe third country. That's my submission on the Refugee Convention. I should mention that in the Divisional Court, we advanced a further answer to the appellant's reliance on Article 31 of the Refugee Convention. And I simply mention it because I'm not arguing this point, but can I mention it? Because I don't want it to be said that the Secretary of State has in some way abandoned this contention. Article 31 says that it only applies to refugees who were coming directly from a territory where their life or freedom was threatened. And we did argue that we argued in the Divisional Court that none of these asylum seekers had come directly from the country of feared persecution. They'd all stopped, some of them for lengthy periods in France and other countries along the way. And we mentioned this in our skeleton argument at paragraph 59 in footnote 75. The Divisional Court simply didn't address this issue. It was fully argued, but it wasn't addressed by the Divisional Court. No doubt because it was unnecessary for it to do so, because in any event it had rejected the Article 31 ground for substantially for the reasons that I have been advancing. I should mention the Divisional Court addressed the Refugee Convention points at paragraphs 119 to 126 of its judgment. My Lords, I'm not
subject of a respondent's notice.
There is no respondent's notice on this, and that's why I'm not proposing to argue this further point, but I should make it very clear indeed that the Secretary of State's position is that if, contrary to her argument that I'm advancing, Article 31 were to have some application, that removal is a penalty in these cases, the Secretary of State maintains her position and will rely on it in any future context that it is necessary to do so, that in any event, persons such as these appellants have not come directly from the country of feared persecution. That concept is now governed by Section 37 of the Nationality and Borders Act 2022, but it's not necessary to go into that because it's not part of my argument today. But I just thought it right to mention that so there can be no ambiguity that the Secretary of State is not abandoning the point for future purposes. So that's my argument, my lords, on the first matter that I need to address. My lords, may I then turn to retained EU law? Mr. Drabble's argument that the Secretary of State is acting in breach of retained EU law, that is, provisions of the Asylum Procedures Directive. And the argument here, as your lordships will recall, turns on the meaning and effect of the 2020 Act, the Immigration and Social Security Coordination (brackets EU Withdrawal close brackets) Act 2020, and that act can be found in volume 29, which is headed Third Supplementary Authorities Bundle, volume 29, and the act is at tab number 9, and it's page 145. And your lordships saw this, seems a long time ago, but I think it was yesterday, the day before yesterday, Tuesday. And your lordships saw that the long title refers both to ending rights to free movement and, in the second line, to repeal other retained EU law relating to immigration. Section 1 tells us that, well, first of all, the heading is free movement, etc., so it's not confined to free movement. And the substance of Section 1 refers to Schedule 1, making provision to end rights for free movement and ending other EU-derived rights and repeal other retained EU law relating to immigration. And my lord, the Master of the Rolls, said, reminded us on Tuesday that there is authority in the arbitration context, that the phrase relating to is a broad concept. We would respectfully agree. In the present context, there really is, in my submission, no difficulty here about the scope of the phrase relating to, because that phrase appears in Section 1 as an explanation of the provision which is made by this Act in Schedule 1. It is Schedule 1 which sets out in detail what Parliament has decided. Schedule 1 makes provision to, and A and B summarises what it's doing, and one of the things it's doing is to end EU-derived rights and repeal other retained EU law relating to immigration. But if one wants to know what that means, one goes to Schedule 1, paragraph 6. That's
Lord Panic, it's said against you, isn't it, that Section 1 is determinative, that it's the scope of the Act is determined by Section 1, and the schedule is explanatory. What do you say about that?
Well, I say that Schedule 1 spells out what Parliament means by Section 1B, relating to immigration, which is...
Schedule, I mean, just so you can answer the point directly, Section 1 says that Schedule 1 is making provision about X.
Yes.
And they say you can't go beyond X.
Well, I'm not seeking to go beyond X because I say that the Procedures Directive is a provision relating to immigration. And if that's all that was in the Act, I would still maintain that position. I say plainly, a directive dealing with questions of asylum law relates to immigration for reasons I'm coming on to. But I do say that you can't look at Section 1 in isolation, because the whole point of the schedule is to spell out in more detail what Parliament itself regards as the scope of the excluding provisions. And I respectfully say that Mr. Drabble's approach provides no purpose for Schedule 1. One can't ignore Schedule 1 when that is the very provision that Section 1 refers to. Schedule 1 makes provision in relation to A and B. If one wants to know what is covered by B, one's not merely got the assistance of a very broad phrase relating to immigration. One has a schedule which spells it out in some detail, unsurprisingly. So if we go to Part 3, which is page 153, paragraph 6, any other EU-derived rights. 6.1 has two parts. It has A and it has B. So if we just look at the language, it's important to do so because my Lord, the Master of the Rolls, asked Mr. Drabble what is his submission on the words in Schedule 1, paragraph 6.1, A and B. And with great respect, Mr. Drabble's answer ignored the question because his only answer, and
It's happened before, Lord Panic.
but it's important to understand why, of course. His only answer is, well, it doesn't matter because you need to look only at Section 1, you need to look at explanatory material and the rest of it. I say the starting point, and indeed the finishing point in respect, is what Parliament has said. And Mr. Drabble doesn't want to address those provisions because he has, I say, no answer. 6.1, any other EU-derived rights, powers, liabilities, etc. So far as A, they are inconsistent with or are otherwise capable of affecting the interpretation, application or operation of any provision made by or under the Immigration Act. Now that is a remarkably broad statement as to what is excluded by this provision. I say at the very least the EU rights in the Procedure Directive on which Mr. Drabble relies, they are at the very least capable of affecting the application or the operation of a provision, any provision, made under the Immigration Acts. And the reason for that is clear. The bulk of United Kingdom asylum law and procedure is found in the immigration rules, and in particular the rules with which we are concerned. And those rules, of course, are made pursuant to Section 3, subsection 2 of the Immigration Act. And what those rules do, the asylum rules, is they regulate the circumstances in which the Secretary of State exercises her powers under the Immigration Act to, acts to grant or refuse a person leave to enter or leave to remain in the United Kingdom. And if there were any doubt about this, and there is none in my respectful submission, the meaning of the term Immigration Acts think, my Lord, the Vice President raised this point with Mr. Drabble on Tuesday. The meaning of that phrase is expressly addressed in section 4 of this Act. If I could invite the Court to turn back to page 147, we see there's a reference on page 147, section 4, headed Meaning of the Immigration Acts. And we're told that in section 61 of the UK Borders Act 2007, this Act is to be added. So we need to go to section 61 of the UK Borders Act in order to see its scope. Its scope is in, it's the same volume, yes, the same volume, volume 29.
Sorry, I'm not quite following you, Lord Panic. I'm sorry, you're just going a bit quickly.
I apologise. I'm on section 4.
You've section 4, yeah.
At page 147.
And that says in section 1 of the Borders Act.
Section 61 of the
61.
UK Borders Act,
Yeah.
which defines the Immigration Acts,
Yeah.
there is to be added, CB, that Parliament has added Part 1 of the Immigration and Social Security Coordinate. Now, this Act is added.
It's rather odd. It doesn't actually say, as you would expect, in an interpretation section, for the purpose of this Act, the 2020 Act, the Immigration Acts has the meaning in section 61 of the UK Borders Act.
No, but that's...
It does use that phrase parenthetically, but in the context of trying to, of simply making sure that in the 2007 Act, this Act is included in the definition.
Yes,
So
but
it's not the obvious way of doing it.
No, but it does achieve it if one looks at what section 61 says.
I see. Okay.
And can I invite your Lordship's attention to tab 6 of this same volume at page 72, UK Borders Act 2007. Page 72, tab 6. And we see section 61.2, a reference in any enactment to, quote, the Immigration Act is to, and then there's a long list of what Parliament regards as the Immigration Act.
I see. No,
And there's a new one, which is the 2020 Act. So it does, in my submission, achieve the objective that
and
the Lordship...
including asylum legislation.
Yes.
Including asylum.
Yes, absolutely.
Yeah.
Well, it includes a number. It includes a number of acts. I'm not going to go through them all, but can I just mention, for example, G. 61.2 G is the Asylum and Immigration Treatment of Claimants, etc. Act 2004. Now that is the very act by reference to which the Secretary of State has exercised powers, Schedule 3, Part 5, to remove or to certify the removal of these appellants. Now, I'm coming to Mr. Hussein's argument that the Secretary of State can't use Part 5. He says you can only use Parts 2, 3 or 4. But the point is that that very act is the act which addresses removal of asylum claimants. So it is, I say this with the greatest of respect, it is quite impossible for Mr. Drabble to contend on the language of Schedule 1, paragraph 6.1a, that we are not here in relation to asylum. We're not within the scope of 6.1a because there's some sort of distinction, he says, between immigration and asylum. That just doesn't work. And if that were not good enough, there's then B at 6.1b of the schedule on page 153, because these are supplementary to each other. And B is any other EU-derived rights. This is the heading. So far as B, they are otherwise capable of affecting the exercise of functions in connection with immigration. can it seriously be suggested, I ask rhetorically, that the Secretary of State's approach to asylum in this case is not capable of affecting the exercise of functions in connection with immigration? It is unreal to suggest to the contrary. The Secretary of State is deciding whether or not a person should be considered here on the merits of her asylum claim for permission to enter the United Kingdom and remain in the United Kingdom. So that's why Mr. Drabble has no answer to the question from my Lord the Master of the Rolls. What does he say about the text of Schedule 1, paragraph 6, 1A and B? There is no answer, and he is therefore left with what I say is the barren submission that one ignores what Parliament has said, or one seeks somehow, I respectfully do not understand how, one somehow seeks to interpret paragraph 6.1 in a narrow manner that is said to be consistent with section 1 when it is not, because section 1B contains the broad phrase relating to immigration, and in any event, section 1 tells us that schedule 1 makes provision about all of this. So I say that if one looks at what Parliament has enacted, there is no retained EU law in terms of the Procedures Directive. And of course, this is very familiar territory. The Supreme Court has made very clear indeed recently that statutory interpretation is an exercise in identifying the intentions of Parliament, primarily by reference to what Parliament has said in the language of the statute. I'm not going to take time on it, but the authority is the Project for the Registration of Children as British Citizens. And for the court's note, it's in volume 24, which is supplementary bundle 2, tab 40, and the page reference, the report starts at page 1559, and the relevant passage for your lordship's note is Lord Hodge speaking for the Supreme Court, paragraphs 28 to 30. Mr. Drabble then, I say because he has no case on the language of the statute, relies on extrinsic aids. I say they cannot assist him given the lack of any ambiguity in the legislation. But for what it's worth, I don't accept that the explanatory memorandum assists in any event. And we go to Mr. Drabble focused on the explanatory memorandum and then the memorandum to the Delegated Powers Committee. The explanatory memorandum is in volume 26, which is supplementary bundle 4, and it's, your lordships will find the document at tab 87.
So what's the unique bundle number?
Unique bundle number 26.
Oh, 26. Thank you. Yeah.
Supplementary bundle 4. It's tab 87, and it's page 3219.
Essentially, you call it explanatory memorandum. There is some significant. It's actually, aren't they explanatory notes?
No, these are not the explanatory notes. Sorry, explanatory notes. I apologise. It's the explanatory.
I'm not being picky. There is some difference.
No. Your lordship's absolutely correct. They're explanatory notes. Can I just remind your lordships what is said at the beginning of this document at page 3219, and the first bullet point. It's a statement of the obvious, but these explanatory notes have been prepared by the Home Office in order to assist the reader of the bill and help inform debate on it. They do not form part of the bill. They have not been endorsed by Parliament. And then the bottom and the last note, these explanatory notes might best be read alongside the bill. They are not, and are not intended to be, a comprehensive description of the bill. Mr. Drabble then relies on page 3231, and it's at the top of the page, part 3. It's dealing with part 3 of what became the 2020 Act, EU-derived rights, etc. And it tells us correctly that the 2018 Act saves, as part of UK law, directly effective rights that currently flow through Section 2.1 of the European Communities Act 1972. And there's some detail. And the final sentence, a number of these rights could otherwise be relied upon in an immigration context.
I'm so sorry, Lord Panic. Which paragraph are you
I
in?
apologise. 66.
66.
Yeah,
I'm sorry.
page
That's my fault.
3231. The first sentence
Yes, I've got you.
accurately describes the European Union Withdrawal Act, and the final sentence recognises that a number of these retained legal rights could otherwise be relied upon in an immigration context.
Otherwise means otherwise than
Than the Act.
the bill, yes.
Yes, than the bill. 67, Part 3 of Schedule 1 disapplies other retained EU law relating to free movement of persons, and it deals with that. 68, paragraph 6 ensures any directly effective rights that will have been saved by the 2018 Act and would, in the absence of this paragraph, be retained, cease to apply insofar as they are inconsistent with or are otherwise capable of affecting the interpretation, application or operation of immigration legislation or functions, which is a fair summary of what is in paragraph 6.1 of the schedule. And indeed, that sentence is, with respect, inconsistent with Mr. Drabble's suggestion that one only need look at section 1, one doesn't need to look at paragraph 6. And then it goes on for example. So it gives non-exhaustive examples, and over the page there's a list which Mr. Drabble referred to at 3232. The following is a non-exhaustive list. So it's not intended, it's not purporting to be comprehensive. None of that, in my submission, can assist the appellants, given what the Act actually says, and my suggested, the analysis that we give by way of submissions. The other document is in the...
It's a bit odd, isn't it, Lord Panic, that there's no reference to the asylum materials at all in that non-exhaustive list. I mean, you'd accept that.
Oh, I don't suggest there is any. I can't explain why not.
No.
But there it is. The question for the court in my submission is not to try to identify whether there is or is not a good explanation. The task of the court, in my respectful submission, is a more prosaic one. It is to look at the language that Parliament has enacted and to decide whether or not it covers that upon which Mr. Drabble relies. And for the reasons I've given, I say that if you pose that question, there is and can only be one answer. And Mr. Drabble has not seriously suggested to the contrary.
I mean,
The other
it's a
document...
bit hard to say there can only be one answer with the Supreme Court sitting. And you're going to come to it, of course.
Oh, I'm coming to that, yes. Yes, I'm certainly coming to that.
Bit of a binary submission.
Well, I do submit on the basis of the language. I mean, normally I like to put my submissions in modest terms, but I do submit, if you look at the language of what Parliament has enacted, there is one answer, and one answer only. and it is not reasonably possible, in my respectful submission, to arrive as another approach to the words in paragraph 6. But I'll come to the Supreme Court. Before I do, the other document that Mr. Drabble places reliance on is at tab 86, which is page 3207, and this is the report of the Delegated Powers and Regulatory Reform Committee, and what Mr. Drabble relied upon at page 3212 is the Home Office response to the recommendation of the committee, which was concerned about what it described as inappropriate delegation. And just to remind the court, at 3212, in the middle of the page, under the recommendation that the words "or in connection with" are removed from clause 4.1, the Home Office response is that the changes which can be made using this power are restricted to those which are appropriate in consequence of or in connection with the provisions in Part 1 of the Bill. So far, so good. They can therefore only be used in relation to the ending of free movement and protecting the status of Irish citizens. Now, with the greatest of respect to the Home Office, that is plainly wrong. And it is plainly wrong because we all agree that Section 1 of the Act is not confined to free movement, or indeed to the status of Irish citizens. The legislation, and this was a question that I think my Lord Justice Underhill, my Lord the Vice President, put to Mr. Drabble, does he accept that Section 1 of the Act covers not merely free movement, but also covers immigration, whatever that means? And he said yes. And he has to say yes, because that's the distinction in Section 1 between A and B. So for the Home Office to say in that comment can only be used in relation to the ending of free movement and protecting the status of Irish citizens, which is Section 2 of the Act, is, with great respect, not correct.
Is a statement of this kind by the Home Office to a parliamentary committee admissible anyway? It certainly doesn't have the status of explanatory notes.
It doesn't have the status of explanatory notes. I'm aware of no authority that would suggest it does have admissibility. It is, to use the phrase I think was used on Tuesday by my Lord the Master of the Rolls to Mr. Drabble, the court is not interested in the views, right or wrong, of various people who have looked at this Act, whether they have to apply it or not. The court's concerned with what the legislation says. And the views of the Home Office, by way of a response to a critical report, if they are admissible, their comments, they have very, very little weight. And they have particularly little weight when what he said is, I repeat with the greatest of respect, plainly wrong on any view. That is the view of Mr. Drabble, myself, and the questions put by the court to Mr. Drabble. The Act is not, Section 1 is not confined to the ending of free movement. It's not confined to protecting the status of Irish.
Well, Lord Panic, I think it was actually my observation about people's random views, as it were, not being very helpful. But the way these reports tend to be produced by parliamentary committees is to have a good deal of discussion and analysis leading up to a recommendation, and it's a very familiar form. And without knowing what precisely it was that the committee was concerned about, it's very difficult to judge the quality of the answer, because we have, I don't think we've got the committee's report, have we? This is just the government response, have we?
Well, the report is what
Exactly
precedes.
the
The report is what precedes. It's a very short
Yes,
report.
but it refers back to an earlier report.
Yes, it does. It does. Which I don't think we have. And we'll try and find that, but we don't.
Well,
It's
it
in
may-
our list of documents in the skeleton, in which I say it's all reveal the same approach to
All
the
right.
meaning of section
Yes,
paragraph
yes,
65.
I-
It's one of there's a long list. Which
Mr.
I
Drabble, I
thought
have
was-
that. Yes, have that point entirely, but it's simply context that I would just.
No, well, I'm
emphasise.
grateful. I'm grateful. There's another point which Sir James helpfully reminds me of in answer to my Lord the Vice President. There are Article 9 problems here as well,
Yes.
relating to parliamentary privilege, because what my friend is relying upon is a document produced by a committee of the House, and Pepper and Hart is a narrow and specific exception to the principle that the court will not seek to look at and assess what he said.
Well, I didn't mean
in
to
Parliament.
start a hair here. Your real point's one of substance that doesn't carry any weight anyway.
But I thought it right just to remind you,
Yeah.
Lordships, of that as a further problem. Then, and I'm grateful to the Master Rolls, I'm now coming to the authorities. There are two Supreme Court judgments upon which Mr. Drabble draws attention to. Can we go back to those? The first of them is the Robinson case, which is Core Authorities. It's volume 21, Core Bundle 3, but it's volume 21. And the Robinson case appears behind tab 57 at page 2112. And the relevant passage is at page 2132. And Lord Stevens is looking at this matter before the withdrawal date, because the judgment is December 16th, 2020. So his Lordship, Lord Stevens, is looking forward to what's going to happen, 2132, and it's paragraph 29. And his Lordship says, as the position after the IP completion date, the current position is that the regulations and relevant provisions, to the extent they're not implemented in domestic law, will continue to have effect as retained EU law pursuant to the 2018 Act. However, this is subject to the 2020 Act, as well as secondary legislation made under it. This Act provides for repeal of the main retained EU law relating to free movement. To which I respond that that's what Lord Stevens was concerned with in that case. But Lord Stevens is not purporting to give a detailed explanation of the scope of the 2020 Act. And that is apparent not least from the fact that Section 1, Mr. Drabble agrees, and I agree, covers not just free movement, it also covers immigration, whatever that means. What Lord Stevens most definitely was not concerned with was the scope of the reference to immigration, the relationship between Section 1 and Schedule 1, and whether or not immigration in that context covers asylum. He then says in paragraph 30, the present position is that the UK's withdrawal from the EU has no impact on this appeal, but the legal principles to be applied may change after the 31st of December. That, my submission, doesn't help Mr. Drabble. There's no considered assessment of the meaning and effect of the 2020 Act in any respect that is relevant to the present case. The other authority on which Mr. Drabble relies is G and G, which is in the same bundle. Core Authorities 21, that's bundle 3, core bundle 3. And at tab 59, G and G, and the relevant passage in the judgment of Lord Stevens for the Supreme Court is at page 2270 of the bundle. And at paragraph 83 at the top of page 2270, insofar as applicable to the United Kingdom, the principle of EU measures of the Qualification Directive and the Procedures Directive, together the Directive. The Secretary of State accepts the purposes of this appeal, and I agree, that the relevant provisions of the directives are directly effective and remain extant in domestic law as retained EU law after the United Kingdom's withdrawal from the EU. Now, there is no mention in those paragraphs, or indeed anywhere else in the judgment, of the 2020 Act. There's no mention of the 2020 Act in the arguments which are reported in the law report, starting at page 2234. There's no argument, there's no analysis, there's no consideration of the width of the 2020 Act, and in particular, its application to asylum law. I do respectfully submit that it is not the case that it can be said against me that there's some arguable point as to the meaning of Section 1 of the 2020 Act and Schedule 1, Paragraph 6, by reference to these two Supreme Court judgments, when there is neither argument on the issue or any consideration of the issue. It's simply not an issue that's argued or determined.
Was it necessary to the court's reasoning?
Well, it may have been. I don't think I can go so far.
Well, I wondered about that. You may be right, but well, you may be right not to argue that it isn't. But at the time of the original claim, I haven't really grappled with this, but am I not right that at the time of the original claim, the old law was still the relevant law?
That is right, and the Divisional Court point out, it's paragraph 117 of their judgment in the present case, that the most likely explanation for the failure to address the 2020 Act is that the relevant provisions came into force on the 31st of December 2020, which was after the judgment of the Court of Appeal and before the hearing in the Supreme Court. And therefore, says the Divisional Court, it is very likely that the parties did not turn their minds to the matter at all. The detailed answer to your Lordship's question is that the issue in the case was whether the mother's application for asylum, naming her child as a dependent, was to be treated as an asylum application by the child. That was the issue. And the Supreme Court said yes, and the directive was one of the reasons for that conclusion. See paragraphs 117 to 121.
On normal principles, you would judge this at the time of the decision under challenge, which
Yes.
is presumably the decision to refuse asylum for the child. And at that time, the directive remained in force as retained, well, remained in force, possibly not as retained EU law because it was pre-withdrawal date.
Yes.
So the only mistake, if I can put it that way, that Lord Stevens made was to refer to a point which actually wasn't necessary. What was necessary to his reasoning was that the directive should be in force.
Yes.
It didn't matter whether it was in force as retained EU law or otherwise.
Yeah. Well, I see the force of that. Mr. Drabble put his case to your lordships on the basis that it didn't matter for the purposes of his submission whether this was part of the ratio or it wasn't. His argument is look at Lord Stevens. He understands.
Yeah, well, I see all that, but I think that's, for me at least, the really important question is whether it is ratio. Because if it is ratio, then whatever we may think about the rest of your arguments, we're bound by it.
No, you're not, with great respect. And the reason...
Well, because it wasn't argued. That's
Yes,
one of those...
yes. I mean, the authority is very clear that if a point is not argued, then even if it's part of the ratio...
I can't remember what the name of the case is.
Well, the case we've got is FSHD Group Holdings, but it refers to earlier cases.
Yes.
Can I show you, lordships, that authority? It's at volume 20, which is Core Bundle 2, and it's at tab 49. Volume 20, which is Core Bundle 2, and the authority is at tab number 49. It's FSHC Group and Glass Trust.
Which, I'm sorry, Lord Panic, I haven't got the right bundle. Is
I'm
it
looking at Core Bundle Volume 2.
Well, second supplementary one.
No, it's not supplementary, it's Core Bundle Volume 2. Your Lordship had earlier Core Bundle 1, which has tabs 1 to 27, which is 19. We're looking at the next one, which is Core Bundle Volume 2. The numbering is number 20. Bundle number 20.
This helps. The page numbering starts 912.
No, the page number is 174.
I understand the page numbering in the bundle starts. Maybe I perhaps wouldn't.
Oh, I'm sorry. Yes. Thank you.
Well, I think it helps it.
Yes, 912 is the...
No, I haven't got it, I'm afraid. I don't, I'm afraid.
Well, maybe we can hand up. Somebody behind me
Well,
got a copy of that.
I didn't understand, Mr. Drabble, to submit that we were bound by this. In fact, I seem to remember a sort of subclause in the sentence where you said in terms we weren't.
Well, perhaps I could just say, make 2 points in relation to this debate so we don't get too bogged down.
Yes.
The first is that you can't dismiss my position on the basis that you look at the date of claim. It is a Hague Convention case, and it needs to be decided at the time of the sentence removal or otherwise of the child. So the Supreme Court is concerned with the current position.
Yes.
So that line of putting me to one side doesn't work.
Thank you. Is that case in your
It's not a case, it's just an observation that this is about the Hague Convention.
Yes, but that wasn't the point I was asking for confirmation of.
The second point is it binding? The answer is that if a court adopts the position of an unargued position but understands it, then it is binding and the authority is Kadim.
Yes.
And that is what I argued below. So what clearly Lord Stevens knew about ICSA because he said so in Robinson, and that's the true significance of Robinson. But I do not argue that he has adopted, I do not argue now, I did in the division.
Yes, well, that's what I
It is adopted with understanding a fully reasoned argument.
No. All right. So it may be sufficient, Lord Panic, for you just to remind us of the paragraph
Yes,
numbers
that's what
in
I'm
the
proposing to do,
FSHC.
but I know, my Lord the Master
Is
Law...
it the Court of Appeal in that case?
Yes.
Yes.
I've got it now.
I'm very grateful. And the reference is tab 49.
For some reason, we got it both in the law report and
Do we?
yeah, well, 1803 we get it in the law report. Am I going mad?
I think your lordship may be right. Yes, your lordship is absolutely right. The paragraph is 136, which in the law report version appears on page 1842, and it's paragraph 136. I can just read that. Subsequent authorities have clearly established that the suggestion which attracted the Court of Appeal in Jocelyn is a correct approach, and a court is not bound by a proposition of law which was not the subject of argument, because it was not disputed in an earlier case, even if that proposition formed part of the ratio of the case. There's a reference to the Vice-Chancellor, Sir Nicholas Brown-Wilkinson in Hetherington, who said as a first instance judge he was entitled to decline to follow even a decision of the House of Lords in which a proposition of law necessary for the decision was not disputed. After review of the authorities, he concluded the authorities therefore clearly established that even where a decision on a point of law in a particular sense was essential to an earlier decision of a superior court, but that superior court merely assumed the correctness of the law on a particular issue, a judge in a later case is not bound to hold that the law is decided in that sense. And there's a reference to various authorities, including Cadine. And I say that's the principle. Your lordships are not bound. The persuasive authority of what was said in the Supreme Court is, with all due respect, minimal, given the absence of any argument, given the existence of a concession by the Secretary of State. It provides no authority at all for your lordships if the court is otherwise persuaded after hearing detailed argument on the application of the 2020 Act that we are right. I should add that in any event, it would be a remarkable position in the light of paragraphs 6.1a and b of Schedule 1 to the Act, where Parliament has had the specific purpose of removing EU-derived rights if they touch on immigration regulation, were this country still bound by the EU Procedures Directive. The Court is entitled, in my submission, to take note of the elementary fact that one of Parliament's primary objectives in implementing Brexit, for good or for bad, was to ensure that power over who should be admitted into the United Kingdom and in what circumstances should be a matter for Parliament and not for Brussels. But that's very much a supplementary point. That's what I say in relation to Mr. Drabble's EU retained law point. Next is Mr. Hussein's submission that the Secretary of State acted unlawfully by using the powers conferred by Part 5 of Schedule 3 to the 2004 Act, and the Court will find the legislation at volume 29 of the authorities, which is called Third Supplementary Authorities Bundle, at tab 5. Or just, would you just give me a moment? There may be a more accessible version at volume 28. Can I just check that, my lord? Just give me a moment. No, it's the same. Volume 29, Third Supplementary Authorities Bundle, at tab 5, your lordship should find Schedule 3 to the 2004 Act. And Mr. Hussain says that the Secretary of State acted unlawfully in using Part 5 of the schedule, which appears behind tab 5, which starts at page 41. Schedule 3, Part 5 is at page 60. And as I understand it, Mr. Hussain's argument is that the
does this printout actually show which part is which?
Well, it does, but not very helpful. If your lordship looks at page 60, your lordship will see near the bottom of the page the heading Schedule 3, just above the Crown copyright. Schedule 3, Removal of Asylum Seekers to Safe Country, Part 5. So that's where one finds it.
So you should read that as if there's a heading above para 17.
Yes, it may be that
Queen's
your
Printer's
lordship
version is always better.
These provisions have been amended in immaterial respects, and the perhaps looking for the version.
Sorry, I didn't mean to start a problem. I
No.
was just puzzled.
No, it's not a helpful printout, but that's what we have. It may be simpler just to work with that. The argument that Mr. Hussain presents is that the Part 5 cannot be used here, lawfully be used by the Secretary of State, because she's reached, he says, a generic conclusion that Rwanda is a safe third country. And he says that you can't use Part 5 in those circumstances. And we have a number of responses to that argument, the first of which is by reference to the statutory language. If I invite your lordships to look at page 60, paragraph 17, we're told this part applies to a person who has made an asylum claim if the Secretary of State certifies that A, it is proposed to remove the person to a specified state, well it is, B, in the Secretary of State's opinion the person is not a national or citizen of the specified state, it is her opinion. C, in her opinion, the specified state is a place where the person's life and liberty will not be threatened by reason of his race, etc., and from which the person will not be sent to another state otherwise than in accordance with the Refugee Convention. That is her opinion. And I say those are the criteria, and the only criteria for the use of Part 5. And it's not with respect for the court to write in further criteria before Part 5 may be used. That's the first submission. The intention of Parliament is stated in the language which it uses. The second point that I respectfully make in answer to my friend Mr. Hussain is that his submission that if the Secretary of State has formed a general opinion about the safety of Rwanda, she cannot use Part 5, she can only use Parts 2 to 4, is contrary to general principles of asylum law. What I mean by that, my lords, is that in all cases of possible removal of an asylum claimant, the decision maker does need to take into account both the general safety of the country concerned and whether that country will be safe for this individual claimant given their individual circumstances.
Yes, it's ultimately a false dichotomy. It's only the second question. It's, as it were, just a factual accident. Whether the reason why it's unsafe depends on some reason peculiar to him or her, or applies to lots of people.
But absolutely, and it's unreal to suggest that you can, as the Secretary of State, that you can form a judgment on whether Rwanda is safe for person X without forming a judgment on general issues about the safety of Rwanda. Of course, you need also to consider particular circumstances. And there's authority on this, high authority. It's volume 20 of the bundles, Core Bundle 2, which is volume 20, and it's tab 38, and it's page 1207. Tab 38, volume 20, Core Bundle 2, tab 38, page 1207, and this is the Eritrea case in the Supreme Court. It concerns removal to Italy, and as a short passage, Lord Kerr, speaking for the court, at page 1230, paragraph 69 and 70. Paragraph 69, it's under the heading Disposal on page 1230. Paragraph 69, Lord Kerr says that he's going to remit all the cases to the administrative court so an examination of the evidence may take place to determine whether in each case it's established there's a real possibility, if returned to Italy, the claimant would be subject to treatment in violation of the Convention. 70. That examination can only be conducted properly if there is an assessment of the situation in the receiving country. This calls for a rigorous assessment. The court must examine the foreseeable consequences of sending a claimant to the receiving country, bearing in mind both the general situation there and the claimant's personal circumstances, including his or her previous experience. And there's authority cited. This approach has been followed by the European Court. So for my friend therefore proves too much. Whenever Part 5 is used by the Secretary of State, she will have formed a view about the general safety of the country concerned, as well as any particular circumstances relating to the individual. And indeed, it would make no sense in my submission to address the question about the individual without establishing whether in general members whether in general the country concerned is a safe one, whether it complies with the principle of non-refoulement. And it also would make no sense.
I don't know whether this is relevant, but I don't think Eritrea was really about refoulement. It was about Article 3.
No, it wasn't.
It's about Article 3 conditions.
Yes, it was. But the point I'm making is that Lord Kerr says, and I respectfully agree, we adopt it, that whenever you're considering removal to a country said to be unsafe, you look at the general situation, you look at the circumstances of the individual. And it would also make no sense in my submission to require the general evaluation of the country concerned to be undertaken afresh in each case. Of course, the Secretary of State will have a view generally on the safety of Rwanda. The notion of an ad hoc or one-off assessment is unreal. It's inevitable that recurring issues will arise in relation to particular countries which it's desirable to resolve on a consistent basis. My third point on Part 5 is that there is a distinction. The statutory scheme does create a distinction between Parts 2 to 4 on the one hand and Part 5. And the distinction which Parliament has adopted is that if the Secretary of State puts the country concerned on a list which requires parliamentary approval, it's done by statutory instrument, then the Act creates presumptions, irrebuttable or rebuttable, about the safety of the country. That's the distinction. And one sees that in Part 2, which starts at page 43. This is Part 2. And Part 2 is a list of European countries, EU states, plus...
Part 2 being which page?
It starts at page 43. And we know it's Part 2 because, again, and I'm sorry this is the only place we see it, at the bottom of page 44, you can see it's part 2, first list of safe countries. And those countries are all EU states, EEA states, that's Iceland and Norway, plus Switzerland. And if a country is on that list, then there's a statutory presumption. See paragraph 3. Paragraph 3, this paragraph applies for the purpose of determination by any person, tribunal or court, this is page 45, whether a person who's made an asylum claim or a human rights claim may be removed from the UK to a state of which he is not a national citizen. A state to which this part applies shall be treated, insofar as relevant to the question mentioned in subparagraph 1, as a place A, where the person's life or liberty are not threatened by reason of his race, religion, from which he will not be sent to another state in contravention of his convention rights, and from which he will not be sent to another state otherwise than in accordance with the Refugee Convention. B has been amended. B has been amended, so it's no longer an irrebuttable presumption, it's now a rebuttable presumption. And that's because of court cases saying that an irrebuttable presumption would be a breach of the European Convention of Human Rights. But the point remains, if a country is within Part 2, there are statutory presumptions which don't apply to Part 5. So if the Secretary of State relies on Part 5, as she is relying, she doesn't have the benefit of presumptions. And the reason for that is that Parliament hasn't given its approval to the placing of the country on that list.
But if it had, would we be here arguing about the safety of Rwanda?
Well, only in relation to 3.2b, which relates to contravention of convention rights, that is European Convention on Human Rights, because that is now a rebuttable presumption, and I'm sure the appellants would say that it's a breach of Article 3.
But otherwise we wouldn't.
Otherwise we wouldn't, no.
Okay. I'm sorry.
But the Secretary of State has, for whatever reason, has not placed Rwanda on the Part 2 list. And the distinction, there is a distinction between Parts 2 to 4 and Part 5, and the distinction is the presumptions that apply if the country is placed on a list, Parts 2 to 4. But that's the only, that's the main distinction. And the same is true if the country is placed on the Part 3 list, which is another list which starts at paragraph 7, which is at page 50, and that too has a presumption, which is paragraph 8. Paragraph 8.2 again is a statutory presumption. It's an irrebuttable presumption. It doesn't refer to the European Convention on Human Rights. And Part 4 starts at paragraph 12.
Sorry, I'm having difficulty navigating through this. I need some page numbers.
I'm sorry.
So where is the Part 3 list?
Part 3 begins at paragraph 7 on page 50, 50. And the statutory presumption there is in paragraph 8.2 on page 51.
Do we have in our papers either the order or the orders, any orders that the Secretary of State has made? There isn't. This doesn't provide for a list. This provides for simply countries to be specified.
Yes, but specified in the statutory instrument.
I understand that, but do we have?
The question is no. I don't believe we do.
But is there a list, which would not strictly speaking be a statutory list, but is there a list of the countries in respect to which orders have been made?
Yes, I'm sure there is. if there are any, and we will
Yes.
provide it to your lordships.
I think for general background information, I'd welcome that.
No, certainly.
Maybe no such list exists.
Well, we will find out.
Yeah,
I don't
thank you.
immediately know the answer to your lordship's question. And similarly, part 4 begins at paragraph 12, which is on page 55, and that too has an irrebuttable presumption at page 56, paragraph 13.2. And if the Secretary of State is to rely on any of those parts, she needs to make, or invite the Parliament to make, a statutory instrument, see page 63, paragraph 20.
I mean, I find it incredibly difficult to look at these provisions in this format. I've now got the legislation from .gov on my screen. But could we be provided with a copy of this legislation in a readable format in its kind?
Yes, I think your lordships have. I'm just trying to find it, but I think there is a more.
If so, I didn't find it because I've done the same exercise as my lord trying to find it.
Yes. It may
You
be
need to
more
think about
helpful
what's
if we
going to be useful
provide
to
the
the court.
court with the up-to-date version of Schedule 3 in a proper form.
Well, I'd like to see the rebuttable presumption as well. You say it's been changed.
Yes.
I'd like to see what it's been changed to.
Well, I can show your lordship that.
Well,
That
you don't
is
need to show me that.
9th
I
volume.
can look at it myself. But anyway, if we could be provided with a better, more
Yeah.
user-friendly version, you don't need to spend time on it now.
Very well, my lord. I will ensure that we do that. The point I'm making, and your lordship may think I'm making a meal of this, but the point I'm making is that there is a clear distinction between Part 5 and Parts 2 to 4. Parts 2 to 4 contain power on the Secretary of State to put before Parliament statutory instruments which add to Part 2 lists in Schedule 3. And if the Secretary of State does that in relation to a particular country, then presumptions apply. Part 5 contains no presumptions. We have to argue our case before the court, and the court decides, based on the submissions the court has heard, whether or not there is real risks on return to Rwanda. And I say...
Well, hang on, it only has to be argued if there's judicial review sort of the certification.
In relation...
Part 5.
Yes,
So you have to argue your case,
yes.
but there's conceptually the Secretary of State's certificate is conclusive. It's only if you seek to argue that it's been made unlawfully. Sorry, it's a very obvious point.
Yes.
But I think you're oversimplifying it to say that you have to argue your case. You only argue your case if there's been the Secretary of State has done something she shouldn't have done.
Yes,
Parliament
the appellant.
expects that she will be
Yes,
do correctly.
yes. The appellant has to present their case, but they're entitled to do so without any statutory presumptions applying as to the substance of what the Secretary of State has decided. That's the point I'm making under Part 5. There's no presumption.
The purpose of Part 5 is so that Section 77 shouldn't apply.
Yes,
Which means that you can
remove.
remove. Is that true about the other parts? And if not, why not?
Yes, I think it is, because if one looks, for example, at paragraph 14, it
Yes, I see.
specifically
No.
excludes
Yep.
section
Okay, well, that's the answer
77,
to that.
and you will find the same provision in paragraph 9 in relation to part 3, and you
Yeah,
will
okay.
find the same provision in paragraph 4 in relation to part 2. So they each have an exclusion of section 77, non-removal. But my point is that there is no inhibition, there's no statutory bar, which is the point we're arguing about, on the Secretary of State deciding that she will use Part 5 of Schedule 3 as the basis upon which she will make decisions in the present cases. She has no obligation to place a country, to make an order in relation to a country under Parts 2, 3 or 4. Indeed, the whole point of paragraph 5 is to allow her to do so even if she hasn't exercised the powers under Parts 2, 3 or 4. She suffers the disadvantage that the presumptions, rebuttable or irrebuttable, do not apply. That's my answer to Mr. Hussein's point. May I turn to fair procedure? Ms. Kilroy says that the procedure adopted by the Secretary of State in relation to procedure in this country is systemically unfair. And may I remind the court of the general principle that is to be applied by the court in assessing such a contention. The court will find this in core bundle 21, which is core bundle 3, behind tab 56 at page 2076. And this is the A case, very familiar, particularly to the Lord Chief Justice, and the relevant passage is in my Lord's judgment with Lord Sales, to be found at paragraph 67 and 68 at page 2104, tab 56, volume 21, page 2104, where your Lordship referred to the detention action case, and at letter F on page 2104, your Lordship refers to Lord Dyson's summary of the principles in relation to a complaint that a scheme is structurally unfair. That's the context, see the beginning of 67. Court of Appeal struck down procedure rules in relation to a scheme for fast-track disposal of appeals in relation to asylum claims on the basis the scheme is structurally unfair. And Lord Dyson, his principles are set out, G, in considering whether a system is unfair, one must look at the full run of cases that go through the system. Successful challenge must show more than the possibility of aberrant decisions and unfairness in individual cases. System will only be unlawful on the grounds of unfairness if the unfairness is inherent in the system. The threshold of showing unfairness is a high one. And in this, Roman 5, the core question is whether the system has the capacity to react appropriately to ensure fairness, in particular where the challenge is directed to the tightness of time limits, whether there is sufficient flexibility in the system to avoid unfairness. And 6, whether the irreducible minimum of fairness is respected. That's a matter for the courts. And Lord Dyson expressed a note of caution in relation to Roman 4, and your Lordship with Lord Sales says at 68, in our view this statement is consistent with the approach derived from Gillett, which we would apply in the present case. Notably, as Lord Dyson said at point 5, the core question is whether a system which, according to the statutory power under which it was promulgated, had to be capable of allowing every case which the Secretary of State introduced to it to be determined fairly had, quote, the capacity to react appropriately to ensure fairness. So that's
Could you read the note of caution?
Yes, of course. The note of caution is at the top of the page. I accept that in most contexts the threshold of showing inherent unfairness is a high one, but this should not be taken to dilute the importance of the principle that only the highest standards of fairness will suffice in the context of asylum appeals. Of course, I should have read that. That goes to Roman 4, the threshold of showing unfairness. It doesn't go to Roman 5, which is that the core question is whether the system has the capacity to react appropriately to ensure fairness. So that's the test that we respectfully invite the court to apply in the circumstances of the present case. And my friend Ms. Kilroy advances 6 points. Her first point is that the asylum claimant is entitled to make representations on the general safety of Rwanda, as well as in relation to their individual circumstances. And I say in response to that contention that this issue is more academic than real. And I say that for the following reasons. First, the Secretary of State's position, as stated in our skeleton argument in the asylum aid appeal, paragraph 29.2 of our skeleton argument, it's volume 14, which is the asylum aid core bundle. It's tab 4 of that document, starting at CB 44. Our position is that the Secretary of State has said that if any representations are made on wider issues, including the status of Rwanda as a safe third country, they will be considered. That's our position. We are not saying that the applicant is not entitled to make representations on the general safety of Rwanda. And that has been our position from the commencement of this litigation. See the witness statement of Mr. McCaskill for the Secretary of State, volume 3, tab 30, which is the core documents bundle. Can I just give the court the reference? Volume 3, tab 30, page 1082, and the relevant passage is at paragraph 14, which is page 1087. So applicants are not shut out from making representations on whether Rwanda in general is a safe country, and those representations are and will be considered. The notice of intent document invites applicants to submit any reasons as to why their claim should not be treated as inadmissible, or why they should not be removed to another safe third country. Again, I give the reference, volume 3, tab 21, pages 977 to 978. That's the first point.
And is
The
that
second
made
point,
clear to caseworkers in the inadmissibility guidance?
yes, well, the inadmissibility guidance tells...
That is the right place to look, isn't it?
Yes, the inadmissibility guidance tells caseworkers that they must consider anything that is said by way of representations.
Thank you.
I can give your lordships the reference in that document. Can I come back to that?
Yes.
I can't immediately put my finger on. Well, Well, yes. I mean, if you look, if the Lordship looks, for example, can I give the reference? Volume 3, tab 21, page 978. At the bottom of the page, after issuing a notice of intent, TCU, that's the third country unit, must fully review the evidence available, including any representations made by or on behalf of the claimant, and where relevant, undertake any further checks to obtain additional information to support decisions for instance. And at the top of that page, your Lordship see the notice of intent. The notice of intent is there set out, starting at page 977. And the first new paragraph on 978 tells claimants that if they have things to say, they should say them. So the guidance to the officials does tell them that they must consider what he said, and the same is true at the bottom of 983 over to the top of 984. Consider what he said.
I think I understand, if I've got this wrong, sorry, that at least part of the case against you is that the reading in admissibility guidance together with the other country assessments published at the same time by the Home Office, caseworkers might get the impression that Rwanda was a safe country generally, full stop, and that that's where they look for their guidance and will answer any representations to the contrary without the necessity for any specific consideration.
Well, plainly, the caseworker is going to take into account what the country assessment says, but they are open, willing, and obliged, as page 978 tells them, to consider anything that is said by the applicant. There's a certain air of unreality about all of this because it is inherently unlikely that a particular applicant is going to have representations to make on the general safety of Rwanda. They may do, but it's much more likely that what they're going to have things to say about are matters specific to them. But I'll come on to that.
Well, that may be true, but they may, if they're well advised, have sorts of solicitors that are representing some of the applicants in these cases, have a wealth of information about Rwanda, and they may say, look at the latest US State Department report.
And if they do, the caseworker is obliged to take that into account. There is nothing in any of the documentation that tells the caseworker that once the third country document is produced, once the Rwanda assessment is produced, you must close your eyes to anything that is said on behalf of an applicant. On the contrary, they are told at the bottom of 978, review the matter, review any representations made on behalf of the claimant. And it's not suggested by reference to any document, so far as I'm aware, that caseworkers have said, I'm not prepared to consider that. That's already been decided. There's no evidence of that. So I don't accept that criticism. And the Secretary of State has made very clear that she is prepared, of course, for any representations to be taken into account, even if they relate to the general safety of Rwanda.
I think you were taking us to the section that 983 is the country of connection safe.
Yes.
Where over the page there's a reference to the various lists of countries.
Yes.
I'm just looking at the third paragraph on 984, which I'd be grateful for your submissions on. Having looked at the
Yes. For other countries.
part 2 ones,
Yes.
then you've got for other countries or for Schedule 3 countries, where the claimant supports their claims with country information, more detailed consideration may be required, looking at any evidence submitted and country information available to the Home
That's
Office.
what I'm grateful.
I
Precisely.
mean, I thought that you mentioned
Yes.
984, but I
I'm
don't
grateful.
think
I was
you
coming
read
to that, but your
that.
Lordship's quite right. That is a specific requirement in the guidance requiring the caseworkers to consider those matters which relate to general matters concerning the country concerned. So we are prepared to consider, caseworkers are told they must consider, the applicant who wishes to make such representations, and in particular their solicitors, have access to material explaining why the Secretary of State considers Rwanda is in general a safe third country. Each applicant is given an information pack on relocation to Rwanda, volume 3, tab 24, which starts at page 998. The Secretary of State has published the Memorandum of Understanding, volume 3, tab 13, which is at page 678. She's published the CPIN, that's the country note, volume 3, tab 17. She's since, more recently, November 2022, she's published the note verbal. And in any event, what duty requires, I remind you, Lordships, is disclosure of the gist, not disclosure of each jot and tittle. Duty is volume 27, tab 9, page 560G of the law report. I don't invite the Lordships to turn it up given the time, but volume 27, tab 9 starts at page 303, and the material available is much, much more than the gist. Then I remind you, Lordships, I do say that it's unlikely an individual applicant is going to have representations to make on the general safety of Rwanda. They may do, but it is, I say, unrealistic after this litigation has examined the general safety of Rwanda in very considerable detail to think that an individual claimant is going to have anything of value to add to the evidence, argument and judgments in these proceedings other than if there is new material or new events. In those circumstances, I entirely understand, of course. They may have something new to add. If they do, well then they're entitled, of course, to add it. So my
Is this the point just to ask you about particular subgroups? Let us say Muslims, or maybe people of the same sexual orientation. They will raise those points, or may, sorry,
Yes.
if there are points to be made, they may make them. And is it your case that those are sufficiently, that there's sufficient general information about those in the CPIN to make it unlikely that there's more to be said?
Well, I haven't checked whether the CPINs deal with each of those categories, but I'm perfectly entitled to assume for the purposes of argument that there may be groups,
Yes.
particular categories, who are not covered by
Yes.
the CPINs. And if that is the case, and if an applicant says, I am specifically at risk in Rwanda because I am whatever I am, then they're entitled, of course, to present representations which will have to be considered on their merits. There's no dispute about that. So I say that the dispute, and it's not my friend's fault, it's great respect the consequence of the judgment of the Divisional Court, which took the line that the applicants are not entitled to make representations on the general safety of Rwanda. I say that this dispute is more apparent than real, That's my submission. If necessary, I do submit that if it's a general safety of a Rwanda case, there's no entitlement to make representations. It's not a matter specific to the applicant, and the Divisional Court made that point at paragraph 392, and the general safety of Rwanda will have been assessed in the present case and a judgment given. Divisional Court, page 395. Ms Kilroy referred to much authority, but it is elementary to procedural fairness that the requirements of procedural fairness depend on the particular circumstances. They depend on the particular context of the case. Doody, page 560, letter E.
So the Divisional Court overstated the position.
Well, I don't accept that formally by way of concession, but I do prefer to put my submissions on the basis that in the circumstances of this procedure, the dispute is more apparent than real because the Secretary of State is prepared to consider representations, has been prepared from the start, on the general safety of Rwanda, and the opportunity to make such submissions in the light of the resolution of this litigation, if the Secretary of State succeeds, is much, much reduced.
Where did the Divisional Court talk about this, please?
The Divisional Court address this question at paragraphs
392.
yes, starts around 389 and it goes on 390, 392, and Your Lordship finds the conclusions in particular at 392 and on to 395. So I prefer to put the case on that basis. If necessary, I say there is no right to make submissions in relation to the general safety of Rwanda. We've put in a respondent's notice on this point. If Your Lordships want the reference, it's volume 14, tab 3, CV 39. The second point is access to lawyers, and the Divisional Court addressed that question at paragraphs 403 to 407 of the judgment. As stated by the Divisional Court at 405, each of the applicants was informed about the state-funded duty solicitor scheme as part of his induction when he arrived at the Immigration Detention Centre. And that's also set out at paragraph 30 of the judgment. Mr. McCaskill explains the arrangements that are made through the legal aid agency for the provision of legal advice surgeries at immigration removal centres. That's at volume 3, tab 30, pages 1093 to 1095. It's paragraphs 32 to 36 of Mr. McCaskill's witness statement.
So which paragraphs do you say?
32 to 36.
Oh, that's the paragraph.
Yes, that's the paragraphs.
Yep.
Of Mr. McCaskill explaining how it works. The Divisional Court was satisfied there was no procedural unfairness here. In our
So I can just understand this. That's effectively when they step out of the boat onto the beach, they're taken to a detention centre within hours, and that's where the duty solicitor is. At that point, they will have had no notice of intention suggesting they may be taken.
No, that comes later.
Yeah, so the duty solicitor won't be able to advise by that, say
No.
perhaps to say it's on the cards that this may happen in your case.
No, but they have access. It's not on a one-off basis. The ability to go and seek legal advice from persons there is a continuing opportunity. So once they get their notices of intent, they're able to go.
If they're still in detention.
Yes, they're still in detention. We're talking about people who are in detention. If they're not in detention, they have 14
Yes,
days
no,
rather than 7 days.
Okay, thank you.
The third point that my friend Ms. Kilroy raises is the requirement to make representations within 7 days if the asylum claimant is in detention, 14 days if not, the trigger event being the notice of intent. My submission is that 7 days may or may not be adequate. It depends on the case. But the point is that the individual can request an extension of time. See Mr. McCaskill, volume 3, tab 30, page 1090, paragraph 23. And he adds, even if an extension is refused, further representations are considered. And in the cases before the court, extensions were requested and often granted. Not always, but were often granted. I say that the existence of a system for granting extensions means that the process here does satisfy the test in the A case, in that the system has the capacity to avoid systemic unfairness. If extensions are unreasonably refused, that is a reviewable decision. But the system allowing for flexibility is adequate. And of course, there's a very sensible reason in my submission why the standard time period is as short as 7 days. That's appropriate in the public interest so that decisions on possible removal to Rwanda can be made without delay. It's also in the interests of the individuals concerned if they're in detention. And I say, in the abstract, it cannot be said that a procedure which allows for extensions is structurally unfair. In the abstract. My Lord, the Vice President drew our attention to the Refugee Legal Centre case, of which we have copies. He handed them out. Can we, with the assistance of the usher, hand up copies? I think my friends have this because we sent it to them. Yes, well, if you want hard copies, we've got hard copies. Thank you very much. Thank you. This is the Refugee Legal Centre case. And your Lordships will see from the head note, as the Vice President indicated, the very speedy...
We won't see anything till we've got it.
No, you will see it. You absolutely will see it.
Yes, you did say will.
You will see. When your Lordships have it, I'm grateful to the usher.
Yes.
Your Lordships will see from the head note that this was truly a fast-track system. It was a pilot system for the adjudication of asylum applications. I emphasise substantive asylum applications. They're made by single male applicants arriving in the UK from countries where the Secretary of State believed there was no serious risk of persecution. Under the scheme, applicants whose cases were considered straightforward enough to be suitable for fast track were taken to a removal centre near Heathrow. On the morning of the day after their arrival, the applicant was given the opportunity to instruct a legal representative. In the afternoon, the interview would take place. There was no formal opportunity to make supplementary representations before the written decision was given on the next day. According to the Home Office statistics, all but 5 of the 1,200 cases were refusals. The claimant, the RLC, was concerned with the provision of legal services. It sought judicial review on the basis this was inherently unfair and unlawful. It compressed the decision-making process into 3 days. The Home Office filed evidence asserting that claims which turned out to be particularly complex were removed from the fast-track scheme, and the caseworkers were encouraged to adopt as flexible an approach as possible without compromising the integrity of the process. And my Lord, the Vice President, drew attention to the fact that, well, first of all, the claim was dismissed. Secondly, my Lord, the Vice President, drew attention to the fact that in paragraph 18, Lord Justice Sedley, speaking for this court, referred to what was lacking is a clearly stated procedure in public law policy which recognises that it will be unfair not to enlarge the standard timetable in a variety of instances. And my Lord put, by way of argument, that perhaps that was a valid criticism that could be made of the present system here. My answer to it is that, notwithstanding that concern, Lord Justice Sedley for this court dismissed the application of the appeal, and he did so, if your lordships look at paragraph 20, the initial question remains to be answered. Does the present system, considered in the round and at the point of entry, carry an unacceptable risk of unfairness to asylum seekers? Which, of course, is not quite the same question as A, but nevertheless. And he says, he refers to what Mr. Justice Collins has said about flexibility. At 22, our reason for reaching the same conclusion, that is to dismiss the claim, slightly different. We accept the submission. There is a tension between flexibility and unwritten, imprecise, but underlying policy. If this underlying policy were allowed to subvert proper individual requirements of more time, it would compromise the system because it would create unfairness. An individual case in which it could be shown to have operated to an applicant's detriment would, subject to questions of mootness and standing, be justiciable. And then at the end, paragraph 25, we have recognised the risk. We've indicated what, in our view, needs to be done. But like Mr. Justice Collins, we do not consider that the system itself is inherently unfair, and therefore unlawful. On the contrary, as long as it operates flexibly, as the Home Office accepts it should, the system can operate without an unacceptable risk of unfairness. Although, therefore, a material part of the RLC's concern needs to be addressed, Mr. Justice Collins was right to refuse relief, and the appeal consequently fails. Now, I say that a fortiori, the present case has flexibility built into it. The Home Office, the Secretary of State do recognise that in appropriate cases, that is where reasonably the claimant needs more than 7 days in all the circumstances, then extension should be granted. And it may be
recognised in evidence.
Well, we've recognised in evidence that flexibility is an inherent part of that system, because that's what Mr. McCaskill says.
I suppose what I was getting at is, suppose that the general thrust of your submissions is right. Would this be a case where it would be appropriate for this court to drop the very clear, make some very clear observations that it's not enough just to say we were always aware of the need for flexibility, but there must be a policy about it, which is what is said in para 19.
Yes. Well,
if your lordship say we always have regard to flexibility, systems don't work that way.
The difficulty with a policy is that a policy suggests that the Secretary will set out the sort of circumstances in which extensions will be granted. And to seek to do that inherently derogates from flexibility, because there is a real risk that it doesn't lead to consideration of particular circumstances of particular cases, but becomes a tick box exercise. That's the concern. And that's why the Secretary of State has preferred to adopt the view that where appropriate, extensions can and will be granted. It may be that this is an area where, if this appeal were to be dismissed and the policy goes ahead, experience will provide illumination. And it may well be that the Secretary of State will think that this is an area in which further guidance is appropriate. Well, I'm reminded by Mr. Brown that in the A case, paragraph 47, the court said it is not incumbent on the administration to have a policy. You know, it depends on the circumstances.
Well, I think, Lord Panic, that was dealing with the type of argument that we've all encountered, that looking at any document, it is possible to say, but what if, and why isn't this covered, and why isn't that covered? And occasionally those arguments were getting home. And in A, the observation was made in that sort of context.
Well, I'm grateful. So I say it's not, it doesn't make it structurally unfair to have the system that we have at the moment. The system is flexible, and that suffices for the purpose of A. That's ground 3. Ground 4, disclosure of provisional conclusions. I can be brief, I hope, on this. My friend Ms. Kilroy says the Secretary of State is obliged to inform the applicant of a provisional conclusion. In my submission, no. The applicant is informed in the notice of intent that the Secretary of State is minded to make a removal decision, and he or she then has the opportunity to present representations on why that is not the right course to take. I say there's nothing in the concept of procedural fairness that requires the Secretary of State to send a second document setting out further provisional conclusions, triggering another round of representations before a conclusion is reached. Procedural fairness requires that the applicant knows the gist of the case against him or her and has an opportunity to answer it. And that's what they have. And then a decision is reached. Again, there's no structural unfairness here. Ground 5 of Ms. Kilroy's 6 points is a complaint about access to justice. She says that 5 working days after the decision is not sufficient to bring a challenge to the court. But of course, by this stage, the claimant has already had the notice of intent. The claimant has had an opportunity to make representations, has had an extension if appropriate, has had a reasoned decision, and will have available to him or her material which supports what representations they have made. And I say it is consistent with fairness to say if you want to bring a challenge, you have 5 days to do so, or indeed to say to the court, we wish to have a stay because it's unfair in the circumstances to require us to put forward our full case within those 5 days. Again, there's no structural unfairness. The system has the capability to deal with relevant matters. Again, there's a public interest in getting on with this and not allowing delays to be built into the system if they're not required, and I say they're not, by procedural fairness. Ground 6 is a reference to immigration rules, which I understand to be a reformulation of the earlier grounds, not to add anything of substance or significance, and I wasn't proposing to say more under that head. Briefly, Mr. Drabble then drew attention to the particular facts of his client RM's case, which he, Mr. Drabble, says supports the general complaint of procedural unfairness, in particular the 7-day rule, the 7-day principle subject to extension for making representations. The Divisional Court rejected RM's complaint on his facts as to procedural fairness at paragraph 402. They mentioned at 405 that RM did have access to legal advice. He was given an extension of time. He did make representations. He did produce, in addition, later representations in the form of a medical report, which were considered by the Secretary of State. See paragraphs 331 to 334, 339 and 341 of the Divisional Court judgment. In my submission, the Divisional Court was correct to find, at least entitled to find, that there was no procedural fairness in RM's case. I should mention, for the purposes of completion, that your lordships have also received submissions from the United Nations Special Rapporteur on trafficking in persons. The Special Rapporteur was given permission to make written submissions. Those submissions we have responded to at the end of our asylum aid skeleton argument at paragraphs 63 to 68 in bundle 14, tab 4, which starts at CB 44. And I wasn't proposing, particularly given the time, to say more on that subject by way of oral submissions. We've set out our case. Likewise, your lordships have had written submissions from Freedom from Torture. Their submissions are in volume 31, behind tab 12, which is page EF, page number 51, and we have responded to their written submissions in writing, but I don't think those submissions have reached the court. And again, with the assistance of...
I think, well, they've reached me, Mr. Panic.
Oh, have they? Well,
Must
that's good.
mean- Well, I hope means they've reached others. This
I'm
is
not
Secretary
sure they
of
have,
State's
but why not do
response.
it after the at lunchtime? You're not going to take us through them now, are you?
No, certainly not. No. I'm simply
To
concerned.
save court time.
Yes, well, I'll hand them to the usher. I was simply concerned to ensure that the court has that document. But again, unless I can assist on that, I was proposing not to say more on that subject. I noticed the time. I'm concerned that Sir James will be addressing your lordships in answer to my Lord the Vice President's question about certification. And then Mr. Hopkins is going to answer. Yes, I'm very grateful. There's a list of this is the answer to the other question that was put by my Lord the Vice President. Your Lordship asked a question about the countries to which Schedule 5 of the 2004 Act is applicable, and the answer to your Lordship's question is that Part 2 has a list set out in Part 2 of the countries to which it applies. That's the European...
Oh, I may have misunderstood. I thought that, I saw that, of course.
Yes.
But I thought the difference in Part 2 and Part 3 was that separately,
Yes.
the Secretary of State could make
Yes.
orders
Yes.
in respect of irrebuttable.
Yes, I'm coming to that. I'm coming to that.
Oh, sorry.
I think
Sure.
you
I'm
said
just taking your lordship through.
Okay,
Your lordship
right.
has
First
the
bit
point.
wasn't for problem.
Part two.
I'll
There's
keep
no
quiet.
there's no difficulty about. I'm told that no order has been made designating any country either under Part 3 or Part 4. That's the answer to your lordship's question. I'm grateful. My lords, I've sought to cover a lot of ground. I've not answered each and every point that he's made in the voluminous written submissions. That's not a criticism or a complaint, but I've tried to address what we understand to be the main thrust of the case against the Secretary of State on the issues that I've addressed. If there are other matters, I'm very happy to try to assist your lordships, but subject to that, Sir James will address the court on the certification point.
before you sit down, Lord Panic, I think you're going to get one question.
Yes, of course.
You
from
won't
my
need it.
lord.
I'm anxious not to delay matters, but in the course of trying to work out what representations would be about, I've just been looking again at 345.
Yes.
And again, maybe Sir James better place to answer this, but just a couple of points of clarification. 345B1 is straightforward. That deals with straightforward persecution in the country to which it's proposed to send someone.
Yes.
345B2 deals with non-refoulement. Am I right in understanding that 345B3, although it refers to what I might call Article 3 concepts, degrading treatment, are actually concerned with, sorry,
Looking for my bundle 3, which I have lost. I have so many bundles.
I've been looking at it in the court judgment, but you'll have it lots of places.
Yes, thank you. Yes, sorry.
No, if you want me to go back over it, but my questions are not about 1 and 2, which are straightforward.
Yes. Yes, I'm with you.
Right. 3 raises, as it were, Article 3, but in the context of removal to a fourth country.
Your Lordship is looking at 345
B3.
3. The country is a safe third country for a particular applicant if 3, the prohibition of removal in violation of the right to freedom from torture as laid is respected in that country. Yes, it's talking about whether or not Rwanda, as the proposed safe third country, is not going to remove.
Right. Well, that's fine. I keep this short, but it follows that there is nothing. 345B. Well, sorry, this is out of the way. 4 is concerned with what refugee protection within the country. That presumably means things like the rights you find in the convention, education, access to the job market, and so forth.
Yes.
Right. So if my analysis of 345B is right, there is nothing that allows you to raise what I might call Article 3 issues about Rwanda itself in 345B. And I'm assuming that those questions arise under 345D2. Sorry to bounce you with this. If you want to sit down, and it can be dealt with after lunch, but I just wanted to understand, as it were, under which heads of the rules the various points that are likely to be raised come up.
Yes, I understand. Your Lordship's putting to me that because 345B3 is concerned with removal from the safe third country to another country, the limbs do not themselves address whether Rwanda is a country in which the person concerned will not be tortured.
Exactly. I don't think there's any doubt that that is a relevant matter, but for...
And there's no doubt that that is exactly what he's done.
No, exactly, but I think it's important, if this is going to be to set this out, that we understand at what stage in the process it comes in, and presumably it comes in under 345D2.
Yeah.
Because there's a rather vague word, inappropriate. I don't know what that covers. Presumably it can cover anything.
No. Well, can we think about
Yes, I think I just wanted to raise that.
Right, thank you very much. Very helpful. Thank you. Unless there are other matters, my Lord, that's what I wanted to say on behalf of the Secretary.
Thank you, Lord Panic. Now, Sir James, you've got a sweeping up exercise.
I've got it right. I'll try and set out what at least I understand the position to be. The representations in the AAA cases, the AAA cases, are not in the bundles, but the substance is in the decision letters. And the decision letters in the AAA cases, which you may have seen, are in that core bundle. The AAA.
Yes, of course. I just thought I thought I'd like to see one of the letters to which they were responding.
Yes, I'll see if we can find you references
that's
to that. But just so you have the references to that, the two inadmissibility decisions in AA's case.
I do have those. That's what led me down this trail.
Okay.
Well, it would just help me to have the references
Sorry.
if you've got them there.
It's bundle 7, which is AAA core,
And you need to give us the pages.
and then it's tab 14, 15 and 16. Tab 14 starts on page 619. 15 starts on, tab 15 starts on 623, and the decision on the human rights claim, 631. Well, for the purpose of the judgment and the structure, it's necessary to bear in mind that there are effectively two certification decisions floating about, to put it that way. The first of them is certification under Schedule 3, paragraph 17. And that's a certification by the Secretary of State that, in our opinion, Rwanda is safe.
Yes.
And the consequence of that relates to in-country appeals on whether it is safe and a breach of the Refugee Convention and so on. But you have those provisions set out in the judgment at paragraphs 12, or the ones I'm going to refer to at paragraphs 12 to 14. That's the Divisional Court judgment.
Yes.
And that's one of the bundle of decisions in the inadmissibility decision letters.
Yes.
See the bundle that I've just referred you to, bundle 7, page 629. That's just a certification of the Secretary of State's opinion and is not the subject of a clearly unfounded test, if that makes sense.
Yeah.
That's one thing. Second thing is certification of any human rights claim. That's under Schedule 3, paragraph 19C.
Yeah.
And you get that from the judgment quoted at paragraph 13, 1.3.
Sorry, Schedule 3, paragraph
Schedule 3, paragraph 19C,
Yeah.
which is quoted in the Divisional Court judgment of paragraph 13.
Yeah.
And that does have a clearly unfounded test. And that's considered at the end of the human rights decision letters in AAA as an example.
They're the ones that come from Croydon, rather than the ones that come from Glasgow.
They're the ones that come from, they're the ones, get it now, they're the ones that have a heading that says Croydon in it.
Yes.
Yeah. So they're the ones that come from Croydon. So that's done at the end of that one. So if one went in that particular decision letter to page 652, you'd see paragraphs, improbable as it may seem, paragraphs 160 to 169 of that decision letter deals with those clearly unfounded conclusions.
Yes.
That is, as I say, subject to the clearly unfounded test. Now, there's I understand a massive case law that deals with all sorts of things to do with that test. It used to be manifestly unfounded, as we know, replicates the inadmissibility test in Strasbourg, now clearly unfounded. But you have cases like the Court of Appeal decision in FR Albania, which I don't think is in the bundles, but my Lord is no doubt familiar with. That's Lord Justices Davis, Beatson and Lindblom, I think. If you want the reference to it, it's 2016 EWCA Civ 605, and that summarises quite a lot of earlier case law about about what that means, and also about how the court should go about conducting its review.
Yes.
Right, and you've got a bit of that in Yogathas as well, which is the one that my Lord referred to, which is in the bundle.
Yes. Which I took you to, you remember, for a slightly different purpose, which was to say you shouldn't disagree with the judgment about it or interfere with the friendly foreign sovereign state. But Yogathas is in the bundle, and that also considers these sorts of issues. That, if I can summarise it, the thrust of those decisions, if I've understood it correctly, is to say that at the level of the Secretary of State, clearly unfounded, manifestly unfounded, is a pretty high test. And at the level of the court, when the court is reviewing matters, what the court does is to review that decision, so it's JR grounds, but recognising that the standard of rationality can exist within a spectrum. So you get into anxious scrutiny, which is a subject much beloved or much hated by various members of the court. You get into anxious scrutiny and you get into intensity of scrutiny. But that line of case law attracts a bit of that. But it is essentially a review.
At high intensity.
High intensity, in summary. And then, of course, you've got another level, which is your gang.
Yes.
And so far as the Court of Appeal is concerned...
I didn't understand what you said.
My lord, so
the other level of scrutiny is what?
Your gang, you meant us.
The level of scrutiny at the High Court,
yes,
is review, but intense.
Yes.
And the level of review at the Court, well, the Court of Appeals function is the usual appellate one. So has there been an error of law, or were the reviewing court at first instance wrong?
Yeah.
That's how.
Where did the Divisional Court deal with the question of its review of the certification by the Secretary of State as to human rights?
My lord, I think what they do, I was just about to complete the review of this because it's complicated, but can I just give you one other element before I answer that question? What actually happened below is that you had a challenge to the Rwanda is safe opinion, not clearly unfounded. You have a challenge to the human rights certification, clearly unfounded, and you have a general challenge on human rights grounds, which is effectively mounted in general terms on the basis that all these issues were before the court. So you've got a kind of general Suring type challenge being mounted as well. And what the court below did was to consider effectively all of those aspects together. And then when they come to the individual decision making, to answer my Lord the Master of the Royal's question directly, they deal with the thing briefly, having already analysed the substance and the detail of all the arguments that were mounted, which obviously chime at any and all of those stages I just identified analytically. They deal with that in 179 and 180. And reflecting the structure of the judgment more generally, they distinguish between generic grounds of challenge and individual decisions. And what they effectively do is to say, well, so far as the generic decisions are concerned, there's no basis of illegality made out, whether in relation to the inadmissibility decisions or the decisions refusing human rights, see 179. And then acknowledge that in relation to some cases there might be individual grounds for challenging inadmissibility or on personal circumstances or whatever it may be.
But I think it follows from that the only recognition of the certification element is in the brackets at the end of 179 in terms of actual decision.
My lord, that is the decision that they reach, drawing on.
I understand that, but
and having cited.
That could be significant, could it not, if, as a result of this rather complicated level of reviews, which you've just helpfully summarised, the test was higher insofar as they were looking at certification, because it wouldn't then necessarily follow. It may all seem a bit odd, but I want to get it clear in my mind. It wouldn't necessarily follow from the fact that they had reached their own decision on the Suring grounds that the Secretary of State was entitled to reach the conclusion that it was clearly unfounded and therefore cut out a tribunal challenge.
My lord, that is undoubtedly right as a matter of analysis and as a matter of the structure of the decision making, which I hope I've fairly summarised. But the fact of the matter is that they went through all of the grounds with that mishmash of ways of presenting it, with the slightly different standards you've identified, in play, and then they do reach a conclusion on that.
And there was some debate below about whether or not you do what used to be called an Order 14 thing. You look for summary judgment, as it were. You look for something and then just stop. And I suspect that the position that everyone reached at the end of it was that would not be a helpful thing, given that everyone had gathered. And
It's a fair point.
here we
Well,
are.
Well,
Forget it.
there is again something very rather odd about this, because the approach of the court to all the country safety exercise was to do something not the same as would be done by the first tier tribunal, but pretty close to it.
Yes.
And so it would perhaps strike most people as odd that, having come to the conclusion it had on the substance, that it should then deal with that discrete point, so the whole substance goes back to the first tier tribunal to do it all over again.
My lord, that was the point I was going to finish on.
Yes.
If I may, just trespass on 1 minute so I can leave Mr. Hopkins with a clean start. That was the point I was going to finish on. I suspect that by the end of it, not merely that everyone had enough, but everyone had produced every argument that could possibly be produced under whatever legal guise it happened to be clothed in, whatever the legal standard. And it was recognised, no doubt, by the Divisional Court that they had that this was effectively a generic argument with generic evidence, with exactly the sort of material you would have, no doubt, if you were doing a country guidance case in the tribunal system. You would have all of that in play. Everything had been done. They considered all of that, and they produced their judgment. And in the simplest form, their judgment was that generically things were okay, but things had gone wrong in relation to the individual decision.
Well,
I would rail against hanging them because it's only a bracket at the end of 179.
I do see all that. I see the reality of it. But there is a point of principle here. And it's actually what I did refer to at the end of the NA Sudan case, that if it had been done in the FTT as a sort of country guidance case, practice in the upper tribunal, that's who does them, there would have been evidence and witnesses and so forth. It would have been a different process.
Quite.
My lord, that's also undoubtedly true. But the fact of the matter is that there was all of the material and a mass of it, and the court considered it with conspicuous care. I mean,
but there was no agreement that should be the process.
I don't go and put it that way. There's no agreement about that. The points were raised and argued, as it were. I mean, the slight oddity as well, from the structure of analysis that I identified, is that if they'd been doing it on a JR basis of the clearly unfounded decision, it wouldn't have been it's our decision off our own bat. It would have been a review, albeit subject to intense scrutiny. So to some extent it was swings and roundabouts, and I suspect that the Divisional Court will then to indicate during the hearing and the judgment, this was the approach they took. We're here, we've got all the material, no one's suggesting that we shouldn't reach a decision. We've analysed it, we feel capable of offering a view. That's a view which would sound in relation to the first of the strands of analysis I identified, i.e. the Schedule 3, paragraph 17 thing, and we're not going to cut too finely on the rest of it.
Well,
and no ground of appeal on this, I'm reminded by Lord Cannock. So.
Sorry, that's just wrong.
Well, look, not now, Mr.
Sorry,
Hussain, because we're going to rise now. We'll start again at 2 o'clock. If I've done my maths correctly, Mr. Hopkins will have to finish by 25 past, and then we'll hear from everybody else in accordance with the hopeful schedule we've been provided with.
All right.